Our first presentation today is on Security Takes Center Stage, and it's by Raj Day. We're delighted to have Raj Day here with us from our Washington office. Raj is a partner in the Washington, D.C. office and leads our global data security and data privacy and cybersecurity practice. After nearly 2 decades in private practice and public service across all 3 branches of the United States government, he has held senior appointments in the White House, the Department of Justice, and the Department of Defense, as well as in the intelligence community. Raj returned to Mayor Brown in 2015 after serving as general counsel at the United States National Security Agency, known as the NSA, and under his leadership, our global and multidisciplinary practice addresses the full array of cybersecurity and data privacy issues facing multinational businesses. With that, I'd like to introduce Raj Day.
Well, thanks to all of you for coming out today, and Brad, thanks for that fantastic introduction. If it's bad, I can stay at the podium. That's fine. That's fine. I'll just stay here. That introduction was so kind, even my parents would blush. So thank you, Brad, wherever you are, for that. So it's a timely topic of discussion today: cybersecurity, contracting, vendor management. This is a big, significant area of focus for a number of reasons. And as the person who served as the general counsel at the NSA during the Snowden affairs, I learned the hard way about the importance of contractors to data security. So I think I may in some ways be a particularly appropriate speaker for a topic entitled The Age of Disruption. But seriously, that time at NSA and my previous time in the White House, which I'll talk about in a moment, gave me a pretty good window into the nature of the cyber threats we're facing today. And I thought I'd spend a few minutes talking about that window, talking about some of the developments in the regulatory, legal, and policy space when it comes to cybersecurity, and what are some upcoming issue areas to think about, all with the idea of setting the stage for some of the conversations that will happen over the course of the morning. So by way of background, I rejoined Mayor Brown this past year from the NSA as general counsel, and prior to that, I had served in the role of staff secretary for President Obama. Now, that is a job of reviewing all the paper and managing the paper that goes to the President of the United States on a daily basis. And as you can imagine, there's a lot of threat information that the President sees every day. And in my short 2 years in that role, I saw the amount of threat information going to the President about cybersecurity increase dramatically. Clearly, this became a topic at the highest level of our government. Now, that impression that I got from the White House was only reinforced when I arrived at the National Security Agency as the general counsel. Now, I thought I'd spend a minute to tell you a little bit about NSA and why it's relevant to cybersecurity, because although you've probably heard a lot about the agency post-Snowden, you may be, like many folks, who don't really know what its role is when it comes to cybersecurity. And if you think back 3 years ago in 2012, 4 years now, when I joined the agency, most of you probably hadn't even heard of the NSA, or if you had, weren't really focused on what it did or why it was important. You know, even my own spouse, when I came home one day from work from the White House and I told her I was leaving to take this appointment as the general counsel for the NSA, said to me, "That's really cool. You're going to be the general counsel for the agency that sends astronauts into space?" This is 2012, of course. So NSA, what does it do and why is it relevant to cybersecurity? So there's 3 particular ways in which I feel like that experience informed my view of the cyber threat and informs how we all think about it today. The first is NSA is a spying agency. That's what we all think of, and that mission is called foreign intelligence. It means spying on terrorist targets. It may mean spying on foreign governments, but it also means gathering foreign intelligence about our cyber adversaries, whoever they may be. So think of experiences I had at the NSA where operators would come to me and they would say, "We are literally watching hackers somewhere around the world hack into a U.S. entity because we're spying on them as they're trying to hack into U.S. companies." That's the sort of intelligence that a place like NSA gathers and tries to share with the rest of the U.S. government. Okay, so the foreign intelligence mission of NSA informs our cybersecurity posture as a nation. But 2, one thing you may not think about is in addition to the spying mission, NSA actually has a mission called information assurance. And that's basically the fancy term for a cyber defense mission of what are called national security systems. That's the formal legal term for communication systems used by the U.S. government to transmit classified information. So think of the email system between the CIA and the Pentagon, for example. Think of the need to transmit real-time tactical intelligence to our men and women in uniform all around the world. So think of a commander on the ground in Afghanistan who needs real-time threat information about where explosives may be, and we need a secure way to transmit that information to our soldiers without it being intercepted. So this information assurance mission is effectively a cyber defense mission for the most important communication systems our government uses. So that's the second way in which NSA has a relevance to our cybersecurity discussion. And the third relates to the type of breaches we read about in the papers every day. So when you read about a breach of Home Depot, Target, Sony, pick your corporate entity, you read about one every day, and it says somewhere in the article the FBI is investigating or the Department of Homeland Security is helping the company. What's behind that, chances are, is NSA, helping that part of the federal government determine where the attack came from and share technical expertise. And that's because the most sophisticated technical expertise in our government resides with the folks, by and large, at a place like NSA. And so a good example of that was the Sony hack. And you may recall this was in December of 2014, a hack perpetrated by North Korea, but there were a few days before the government acknowledged who had perpetrated that attack. And while it may have seemed like to the outside world not a whole lot was happening, there was a whole lot happening inside the Situation Room with NSA helping the FBI determine attribution, who caused this attack through intelligence sources and methods. So that's an example of how NSA is relevant even to the types of commercial breaches that we read about on a daily basis. Okay, so what does those functions mean in terms of my view in particular on the cyber threat? I think I'd like to lay a little bit of a groundwork for how we think about the evolution of the cyber threat, because it's evolved quite a bit over the past decade, and if it's not something you think about every day, it really just seems like an onslaught of information. There's no structure within which to put it. So in short, I think in the past 5 years, we've seen cybersecurity evolve from a top national security threat to a global business imperative. And that's a very short window for a single topic to make that move. And what do I mean by that? By the time I got to NSA in 2012, we started to see our national leaders talk about cybersecurity as a top national priority. In 2012, for example, Senator Feinstein, who is the chair of the Senate Intelligence Committee, identified cybersecurity as the top national security threat to the country. And it's a pretty big deal. That same year, Leon Panetta, who was Secretary of Defense, publicly warned about the potential for a cyber 9/11. And the following year, in 2013, Jim Clapper, who was then and is now our Director of National Intelligence, so the top intelligence official in the country, publicly testified that cyber threats are the top threat to the United States. Now, think about that. Every year, the head of the intelligence community goes down with the head of the FBI and the head of the CIA and the head of the NSA, testifies on the Hill in a setting called the Worldwide Threat Assessment. And every year since 9/11, counterterrorism, of course, has been at the top of that list, with WMD proliferation behind that. 2013, so 3 years ago now, cybersecurity, cyber threats, top the list of threats to the country. Pretty big deal. So that's what I mean by top national security threat. But that was 3 years ago. Now, cybersecurity, the reason we're all here is it is a top threat to all of us in our daily lives, professionally and personally. And how have we seen that manifest itself? Well, studies by folks like McAfee, for example, put the cost of data breach and cyber incidents upwards of $500 billion on a global basis. That's a pretty big drag on the global economy. My former boss, the head of the NSA, General Keith Alexander, used to refer to this transition, meaning the transition of the cyber threat from a purely national security issue to a business issue, by saying in his tenure at the NSA, as the director of the agency, we were witnessing the greatest transfer of wealth in human history. And what he meant by that was the stealing of intellectual property by Chinese actors from U.S. companies. And the pure volume and scale of that theft led him to conclude that this was an issue for our business community. This is many years ago. And finally, you don't have to look much further than comments just in the last few weeks by Mary Jo White, the chair of the SEC, the Securities and Exchange Commission, who publicly identified cybersecurity as the biggest threat to the global financial system. Cybersecurity, despite everything we've gone through in the past 6, 7, 8 years since the Great Recession, cybersecurity is the biggest threat to our global financial stability. So how have we seen the cybersecurity threat get to this point, where it is such a significant imperative for the business community? Let me lay out for you a few stages of how the threat's evolved over the past decade, just so you can put it in context and think about that which your procurement officials, your vendors, what everybody is thinking about today. 10 years ago, if you asked somebody, what is cybersecurity about, most would have told you, particularly in the US government, it's about the preventing of stealing stuff, whether that stuff is personal information or intellectual property. It was primarily about preventing stealing, and that phase of the threat is referred to as exploitation. Now, of course, that's still pertinent today. There's data breaches, theft of credit card information every day, but that is, frankly, only one layer of a much more complex threat today. 4 or 5 years ago, about the time I got to the NSA, we started to see layer 2, stage 2 of the cyber threat. And for shorthand, I would refer to that as disruption. First, you had exploitation, then we had disruption. And what does disruption mean? Well, one example might be the types of Ddos attacks, which refers to distributed denial of service attacks, basically when a whole lot of web traffic goes to a particular website and incapacitates that website. We saw a number of Ddos attacks on our Wall Street banks, which brought down their public-facing websites from anywhere for a few minutes to a few days. No long-term damage, but pretty rattling nonetheless for pillars of our financial system, and of course for all of us as consumers, participants in that system. So you had exploitation and disruption. Alarmingly, about a year or two later, 2013 or 2014, we started to see a new phase, a new layer in this complex threat, and that was the threat of destruction. And by that, I mean the types of attacks that started to become public, like the attack on the Saudi Aramco oil company, in which overnight 30,000 computers were just bricked, meaning just turned into useless pieces of metal on the desk, no access to the data, no access to the systems to which they were connected. There hasn't been public confirmation, but there's been speculation that it was Iranian actors involved in that attack. 30,000 computers overnight. Another example, the attack on the Las Vegas Sands Casino in 2013-2014, in which computers were destroyed, again, likely for a political motive. And then finally, the attack I referenced earlier, the attack on Sony in late 2014, in which, in addition to salacious emails from studio executives being released, and in addition to employee information being stolen, we also saw thousands of computers being taken offline as part of that attack. So we had exploitation, disruption, destruction. Now, if you hear officials testifying publicly, they are warning of a new layer of the threat on the horizon. That's here, frankly, but coming. And that's the threat of manipulation. And what manipulation refers to is a whole lot of different things, but there's really two broad strands that I think are worth keeping your eye on, particularly for our topic today. The first is the manipulation of data. So the only thing worse than stealing your data or making it inaccessible or even destroying it is fiddling with it, basically, in a way that undermines the integrity of the entire system of whatever you're talking about. One need not look further than at least the public reports of the attacks on banks around the world and SWIFT to imagine what the consequences could be for undermining the integrity of the global financial system. Manipulation of data. The other strand is the manipulation of physical objects in the new Internet of Things. As more and more devices are connected, there's greater and greater worry about the connection between cyber activity and physical or kinetic activity in the real world. Think of smart cars. That's probably the most common example that affects all of us on a day-to-day basis. As our cars are more and more connected to the Internet for both entertainment, but also, importantly, safety purposes, there are whole new risk vectors involved and whole new players involved, not just from the OEMs, but their supply chain and contractors as well. So manipulation, exploitation, disruption, destruction, manipulation. Now, underneath that broad framework, there's actually a lot going on. There's evolution in the types of cyber adversary actors, and there's evolution in the tactics that are involved. And these are relevant because they impact the types of efforts we take to mitigate the risk, contractual or otherwise. So what's happening in the actors? Who are the people doing this stuff to us, all this bad stuff that I just laid out? Well, if you asked folks maybe 10 years ago, you would have, or even 5 years ago, you would have gotten a pretty pat answer. Most people would have told you, look, there's 3 types of bad guys. There are nation states, and they would have referred to China, North Korea, Iran, Russia. Those tend to be the 4 major nation states we talk about in terms of cyber threats. Bucket 1. You also have criminal groups. Think of all those folks out there stealing credit cards just to turn a quick buck, whether they're in the US, based in Eastern Europe, China, around the world. And 3, you have hacktivist types, those who engage in these activities neither for a financial purpose nor for a political purpose, or at least for a state-sponsored political purpose, but really for some other dynamic. Now, what's become evidently clear over the past couple of years is those 3 buckets are clearly no longer distinguishable. We see state actors funding criminal groups. We see traditional criminal groups working with hacker types to obtain their usual ends. And the import of that is that as a business, as a defense mechanism, as you think about this threat, you have to think about the resources that may be brought to bear against your organization and the strategies that may be brought to bear against your organization that far outstrip anything we may have thought of traditionally. In other words, a criminal group working with a very sophisticated hacker just to steal market-moving information to conduct securities fraud. Traditional type of crime, but they're hooking up with hacker types. Or you think of the resources of a state actor funding a criminal group to steal intellectual property or to conduct an attack like that on Sony for political purposes. The entire point of understanding that complexity is to open one's aperture to thinking about why one might be a target in a way that is far broader than we might have thought of traditionally. Okay, so we've seen this evolution in the actors as well. Now, the other piece of evolution we've seen is with the tactics involved. If you asked folks a few years ago what's the most predominant type of cyber attack, most would have referred to some sort of malware, right? Basically installing some code on your systems so they could get access to your systems. And of course, we still see malware, and signature-based detection is still quite important. And by that I mean, things like McAfee, Symantec, the types of products we have on our home computers and you probably have on your work systems as well, that detect malware through signatures, a fingerprint for the type of code to look out for. But increasingly, adversaries, regardless of where they come from, are preying on the weakest link in any cybersecurity program. And the weakest link, of course, is us, people. No matter what technology you have in place, people are always the weakest link. So what do those attacks look like? I'm referring to things like social engineering. In other words, fooling basically a legitimate employee into giving over their actual credentials so that when the bad guys are on your network, they look like a legitimate employee. It's actually a far easier task to find the adversary who's swimming around in your network and isn't supposed to be there. It's quite difficult to find the hacker who's on your network who looks like you, or the person to your left or to your right in terms of the system. So fooling people and employee training is becoming an increasingly important part of the cyber ecosystem. Okay, so now that I've sufficiently depressed us all with how bad the situation is, what does this mean? What does it mean in terms of the policy landscape? What does it mean in terms of the legal landscape? What does it mean in terms of the regulatory landscape? Well, you can't possibly be in the space or even just read the papers without seeing that there's a lot going on. In fact, too much to keep on top of. There's too much information flowing at us about what this regulator is doing, what law has passed, what's the latest data breach. So I wanted to focus just on a few highlights which I think are important as you consider an overarching narrative in this space. On the policy front, there's clearly an emerging consensus that cybersecurity is fundamentally an exercise in enterprise risk management. It may seem obvious, but it has very important consequences. There, of course, is no perfect security. Cyber risk, like other business risks, is a risk to be managed. It is a risk that needs to be managed in a dynamic and iterative way, given the movement in technology and given the movement in the threat landscape that I articulated earlier. And it's a risk that needs to be managed in a cross-functional way. You know, there's an old joke, particularly in the government, but it applies in the private sector. Cybersecurity brings out the worst dysfunction in any organization because it involves the lawyers, it involves the tech people, it involves the HR people. It cuts across just about every relevant component in an organization and requires them to work together seamlessly. And this philosophy of enterprise risk management has been expressed at the highest level and at the most mundane level. This is fundamentally the driving philosophy behind the Nist Framework, which is the risk management framework that I'm sure you're all at least superficially familiar with, that was put out by the National Institute of Standards and Technology in 2014 at the direction of President Obama. Now, the Nist Framework was really designed to help critical infrastructure manage cybersecurity risk, because that is, of course, the primary concern of the federal government. But it has basically evolved into an important touchstone for businesses regardless of sector, for thinking about a process for how to manage cyber risk. And this risk management philosophy, of course, at the highest level in the Nist Framework, is also reflected in regulatory actions, whether it is guidance or enforcement actions on a daily basis, from anyone from the FTC to the FDA to the SEC. And I'll get into the regulatory stuff in a moment. Okay, so on the policy front, this focus on enterprise risk management. So what's happening on the litigation front when it comes to cybersecurity? You can't read about anything these days without reading about a breach of some company to which you've probably given your credit card information. Well, there's one topic in particular that is worth watching, and that's the issue of standing in class actions that are brought by putative consumers or employees that claim to be victims of a data breach. Now, if you follow these cases over the past several years, you'll know that in most putative class actions brought after a data breach, most of those matters, not all, most, have been dismissed on the basis that plaintiffs, meaning the participants, the customers of the business or the employees of the business, can't actually allege sufficient concrete harm to establish injury in fact, which we all know is one of the critical elements of constitutional standing. And that's because just showing that your information may have been taken in a breach is not the same as suggesting that there was some actual harm that was caused by that breach. But we've seen a number of important developments in the doctrine of standing when it comes to these cases within the past year. And they've cut in different ways, and I think suggest that this is an area that's likely to evolve significantly within the next year. The first and most recent was a ruling by the Supreme Court just a couple weeks ago in Spokio v. Robbins, which was argued by Mayor Brown, one of our partners, Andy Pincus. Now, it wasn't a data breach case, but it was a case fundamentally about this issue of standing, and it's going to have significant consequences in the cybersecurity litigation space. Bottom line was, this was a case about FCRA, the Fair Credit Reporting Act, and plaintiffs made a claim that defendant, in this case Spokio, was in violation of FCRA for various activities they did in collecting information. And the issue on appeal was whether a pure statutory violation without a showing or an allegation of actual concrete harm was sufficient to establish standing. And the Supreme Court said no. Alleging just purely a statutory violation without an allegation of concrete harm is insufficient. Now, the opinion was more nuanced than that, and like most, leaves room for battle from the plaintiff's bar and the defense bar. But this is clearly going to be a marker for data breach litigation for the next foreseeable future. We've seen district courts, one in Maryland within the past week, already relying on Spokio to dismiss these sorts of data breach class actions. That case was the Kahn case in the District of Maryland for anyone interested, which is actually quite a good opinion for having an overview of the state of the law in this space. Okay, so you had Spokio just decided recently. But just as alarmingly, we've seen some other appellate court decisions within the past year cut the other way. And two of the most significant were here in the Seventh Circuit. And those are the opinions in the case involving the breach of Neiman Marcus, the department store, and the opinion involving a breach of P.F. Chang's, the Chinese restaurant, both of which involved credit card breaches, point-of-sale breaches, the type of thing you read about in the paper all the time. And while the decisions by the Seventh Circuit, the panels in both of those cases, were nuanced, the top-line takeaway is the Seventh Circuit basically articulated a theory that the increased risk of fraud or identity theft from a data breach is sufficient concrete harm to allege to confer standing on a putative class. Now think about that. Increased risk of harm by having one's data exposed. The potential for that theory to completely revolutionize the way data breach litigation is pursued is significant. So over the next several months, seeing how those opinions play out, how they're cabined, how they're interpreted, is going to be a major area to watch. Okay, so that's what's the one issue I wanted to focus on in the litigation space. Now let me turn to the regulatory space because that may be most pertinent for the types of issues that you'll be talking about today in terms of vendor management, because this really, I think, is where the action is going to be in terms of risk allocation in contracts and third-party risk. So in the past year or two, we've seen a significant uptake in regulatory attention to cybersecurity across the board. Seen it from the FTC, seen it from the FDA with respect to medical device manufacturers. We've seen it with respect to NHTSA, with respect to car manufacturers. And of course, the financial services regulators, state and federal, have been focused on cybersecurity for several years now. But we've seen some important developments over the past year that I think are worth focusing on. The first is clearly the FTC, the Federal Trade Commission, has carved out and is carving out a leading role for itself in terms of consumer protection vis-a-vis cybersecurity. You've probably at least tangentially heard of the Wyndham decision, which came down from the Third Circuit last year, in which the Third Circuit affirmed the FTC's authority to enforce cybersecurity practices under its unfair practices authority. So in other words, historically the FTC has pursued investigations and enforcement actions under a deceptive practices theory. Did the company's representations about its cybersecurity line up with what it was actually doing? That's a simplification, of course, but really a deceptive practices theory. But in the past year or two, the FTC and other regulators have focused more on an unfair practices theory, which effectively amounts to evaluating whether covered entities are taking reasonable measures with respect to cybersecurity. Now that is a far different exercise of regulatory authority, and one that the Third Circuit just upheld for the FTC last year in the Wyndham decision. So that's a major marker to keep in mind. The second point of focus I wanted to bring your attention to is that unlike the litigation space, regulators are paying attention to cybersecurity irrespective of whether there has been any injury from an incident at a covered entity, and frankly, whether there's actually been an incident at a covered entity. And one need not look any further, for example, than the SEC's enforcement action against Archie Jones last year, in which there was an incident, but there's no allegation of any actual harm to anybody whose information was exposed, and in which there was a consent decree ordered against Archie Jones, or arrived at. Or the newest player in this space, the Consumer Financial Protection Board, the CFPB, which undertook its first enforcement action with respect to cybersecurity just in the past several months against a company called Dwala, which is an electronic payments provider. And in that case, not only was there no harm, there was no incident. This stemmed from an examination of a regulated entity that then had to enter into a 20-year consent decree with respect to its cybersecurity program. So unlike the litigation space, waiting until there's an actual incident in the regulatory space clearly can be too late, and regulators are trying to send the message that they are going to examine this issue irrespective of whether you have shown up or your business has shown up on the front page of the papers. The third thing I wanted to mention with respect to the regulatory space is some areas of focus that seem to be common among regulators irrespective of sector, irrespective of industry. And I'll just mention them here, and I'll focus on the last since that's the most relevant. I think there's certainly at least 4 areas that regulators, and it really doesn't matter whether you're talking about medical device manufacturers, car makers, or financial institutions, that regulators are focused on. The first is corporate governance issues. How is management, and in some cases, boards of directors, managing cyber risk? Employee training, 2. And I think that's a function of an increasing realization that technical protections are insufficient, and humans, as I mentioned, are the weakest link. 3, a continuing focus on written plans and procedures, of course. Financial services entities have had to have written information security plans and data breach response plans in place for a number of years, but increasingly those are becoming de jure and de facto requirements in other spaces. And importantly, not just having a plan on the shelf, but having a plan that is tailored to the risks your business faces. When Mary Jo White made these comments just a couple weeks ago, she indicated there's going to be an uptick in examinations by the SEC. And while the first phase for the past several years had been on whether regulated entities had plans and procedures in place, do you have a response plan in place, do you have an information security plan in place, now the focus is increasingly going to turn on are those plans tailored to the information and systems of your business. So it's not good enough just to have a plan in place, and it doesn't help if in the first interview from your examiner, when they talk to your CISO or your chief information officer or your general counsel, there is a glaring lack of familiarity with the details of that plan. Regulators are now focused on how well are these plans actually implemented. Third major area. Fourth major area, the one I focus on for a moment, vendor management and third-party risk. Obviously, the focus of discussion for today, and I think it's quite timely because it's clearly an area of focus for regulators across sectors. And I thought I'd just take two examples to bring to the fore the focus that regulators have on this area, one at the state level and one at the federal level. The first I'd refer to is a report put out last year by the New York State Department of Financial Services. They put out a report specifically focused on cybersecurity in the banking industry with respect to third-party risk, so specifically on this topic. And I just wanted to read to you a couple of the findings of that report because I think they're informative for how you think about cybersecurity and for how other regulators are going to think about it. First, 95% of the surveyed banking organizations conduct specific information security risk assessments of their high-risk vendors. We would expect that, right? The financial services industry is pretty advanced. Frankly, you might expect the number to be higher than 95%, but that's not that surprising. 90% of the banking organizations surveyed have information security requirements for the third-party vendors, although the nature and specificity of those requirements vary. Again, not surprising. That's exactly what we'd expect. This is a sophisticated industry. Here's a couple of other notable findings, however. While nearly all of the surveyed banking organizations have policies and procedures that require reviews of information security practices, both during vendor selection and as part of their periodic review, fewer than half of the institutions surveyed required any on-site assessments of the third-party vendors. This is the financial services industry, the most advanced when it comes to cybersecurity. Another finding, most of the institutions surveyed require third-party vendors to represent that they have established minimum information security requirements. We would expect that. But only 36% of the surveyed banking organizations require that those requirements be extended to subcontractors of their vendors. Pretty surprising given the interrelation and interconnectedness of our systems. Finally, most of the surveyed banking organizations require the right to audit the third-party vendors. Expected. Yet 30% of the banking organizations surveyed do not appear to require the third-party vendors to notify them in the event of an information security breach or other incident. 30%. I mean, that's shocking given what the obligations are on that sector, let alone other sectors, to interface with your regulators when there's a breach, irrespective of whether it's one of your subcontractors or vendors. Okay, so that was a report by the New York State Department of Financial Services, which, for those of you in the industry know, is a significant regulator of financial institutions. Okay, the second development I wanted to focus on pertains to the FTC, which, as I mentioned earlier, is taking an increasing role in this space. And the FTC put out a report last year called Start with Security. And this report was intended to be a synthesis of the lessons learned from the 50 or so enforcement actions the FTC has taken in the information security space over the recent past. So firstly, it's a very useful document, and I'd commend it to all of you. But one lesson of those principles is particularly relevant to our discussion today. Make sure your service providers implement reasonable security measures, and there were two themes underpinning this part of the report. First, insist that appropriate security standards are part of your contracts. And in one example that the FTC cited, one enforcement action, the FTC alleged that the company that was the subject of the enforcement action hired service providers to transcribe sensitive audio files, for example, but failed to require those service providers to take any reasonable security measures. Seems like an obvious failing. The second major theme of this section of the FTC report was to verify compliance with those provisions. I'm quoting here, including security expectations in contracts with service providers is an important first step, but it's also critical to build oversight into the process. So you can see the FTC2 is focused on implementation of the very types of contractual provisions we're talking about, you will be talking about today. So what can be done about this? And here are some topics that I imagine will be discussed over the course of the panels today. What is the benefit of writing into third-party contracting these sorts of protections? So I think at a macro level, it's important to think about three. It's an important part of an overall enterprise risk management process. Contracting is one way to mitigate that risk, along with other means in your enterprise. Two, it's an important means for ensuring compliance with these increasing regulatory obligations that I articulated. And three, these contracts are an important tool in ensuring effective oversight of third-party, of course, cybersecurity. So there are really many dimensions as to why an organization should engage in this. Now, what should we all, you all, as outsourcing professionals do to be better prepared? Well, I think there's a few top-level things that I know will be of discussion today. First, ensuring there's a structure within your organization to cover these risks, namely a team tasked with responsibility for cyber and privacy risks arising out of suppliers, a cross-functional team. Two, ensuring there is a sound risk-based program in place to assess suppliers, monitor them, and if need be, of course, remove them from service. Three, ensuring that you have sound contractual clauses that appropriately allocate risk and allow for changes in an area that is clearly rapidly evolving faster than the normal contractual cycle. And four, becoming familiar with emerging technologies, things like big data analytics, cloud computing, robotic process automation, the types of technologies that will be discussed today. Now, finally, I just wanted to mention three big picture pitfalls to keep your eye out for, and they derive from some of the discussion earlier. First, don't forget about subcontractors. In this increasingly connected world, as I mentioned, regulators are not focused just on the regulated entities and not just on third parties, but any subcontractors either in the supply chain or otherwise to those vendors. Another hurdle, of course, that you all think about on a daily basis is the potentially limited ability to negotiate with larger service providers. And I know our team at Mayer Brown has lots of strategies for working through those topics, and I think we'll be discussing some of those later today. And three, the third challenge I'd mentioned, third pitfall, is the difficulty and the challenge of assessing compliance with the types of provisions that you work so hard to get into the contracts. Or, even if you can assess compliance, measuring success, big picture. What is success in this world? And I think that's where some of the cross-industry expertise from lawyers who are involved in this topic for multiple clients can come in handy. So let me close by just mentioning three topics that I think are going to be major issues of the horizon and that are actually going to be subject of some of the panels later today when it comes to cybersecurity in particular. The first is an increasing focus on public-private collaboration in this space. And an example of that is information sharing. One recent development in the U.S. was the passage of the Cybersecurity and Information Sharing Act, CISA, last December, which big picture was intended to facilitate information sharing within the private sector when it comes to cyber threats and sharing of information between the private sector and the federal government by creating liability protection incentives to incentivize that type of information sharing. Now, that's just one example of a type of step being taken in this direction, but this is an area of focus not just in the U.S., but globally. We've seen in the UK, for example, the establishment of a new national cybersecurity center, which is going to be the primary interface between the government and private business when it comes to cybersecurity for similar information sharing purposes. So public-private collaboration. Two, developments globally. And I know you'll be hearing from some of my partners today about developments in the EU, whether it comes to Privacy Shield or the General Data Protection Regulation, and of course a raft of developments across Asia that will be discussed later today. So this sort of global perspective. And three, a continued maturation of the cyber insurance market. Now, I think this is a particular area to keep one's eye on because predictions suggest that by 2020 or so, this market is going to mature to about $7.5 billion. Now, predictions are all over the place, so who knows how much stock to put in that. But one of the biggest challenges faced by the insurance industry is a lack of data to sufficiently underwrite cybersecurity policies. And there are a number of long-term efforts underway to help the private sector in that regard. One example, the Department of Homeland Security is working on establishing an anonymized data repository of cyber threat information that could be used by insurance companies over time to have sufficient data to underwrite more tailored and cost-efficient cybersecurity policies. So this is one area where this administration and future administrations are going to be particularly focused on. So let me just close and note that cybersecurity clearly is an area rising to the top of the list for business leaders, regulators, and others. And this increased focus on risk management in particular means there's going to be an increased focus on the mechanisms to manage risk. And of course, the types of contracts that are going to be discussed today are a pretty key element in that. Please think of questions if you have any. Yeah, sir.
This might come up later in the day, but when we ask suppliers to tell us when they have experienced some event or there might be some risk, they sometimes push back and say, hey, wait a minute, I can't tell, we're a publicly traded company, so go look at our public filings. Suggestions?
Well, it's funny, I have another client that has asked that exact question, so we're working through strategies with them. I think there's, unfortunately, and others in the outsourcing practice may have some more specific advice. There is no magic answer. And in fact, that issue of opening up the kimono is one, and the hesitance to do so, frankly, is one that comes up in lots of different contexts. Now, truth be told, every entity, in this case your suppliers, are going to have to make representations to lots of other parties along the way. And so that may be a good starting point for the type of information, in addition to the publicly available information, they should be able to make available to you. Now, another strategy that this one client has worked on is trying to insist on some sort of reciprocity between the type of information provided to suppliers versus the type of information provided back. Now, of course, the success of that strategy will vary depending on leverage and type of relationship and data involved. That's just another tool you can have in your toolkit. Yes, sir?
You're talking about cyber attacks that originate from foreign governments, and for a company that gets, if a company is targeted by a foreign government and I guess finds out about it, is there anything different or anything advice that they should in how they deal with that differently than from any other hacker?
So the question was, if you have a cyber attack and there's indications it's from a foreign government, do you think about it differently? I would say there could be, and the reason is multifold. One is if it involves a foreign government, or at least your outside forensic expert, for example, thinks that may be the case, there's a few different types of things that could arise. One, there's a higher likelihood that the federal government, some part of the federal government, is either aware of that sort of attack or that actor, and so may be aware of that incident and may be approaching the company, for example. So I think there's a larger likelihood of interaction with the FBI or the Department of Homeland Security or Secret Service, for example. That's one way. And two is there may be far more complicated consequences of that attack than any individual business can recognize. And so there may be benefits of interacting with the federal government and educating oneself about the context, which the FBI is more and more willing to do, that may have implications for the security measures you might take. So in other words, it's one thing, just hypothetically, to think, well, it looks like this was an attack on some IP from Chinese actors. They stole some of our plans for our next generation product. That would be one scenario. It might be another if you had the perspective that this is a campaign the U.S. government is aware of that same Chinese actor to go to actors in that industry, and they may have already gone to stage 2 in their overarching plan with others of your competitors in that space. So in other words, the government may have a sense of what's likely to happen to you next based on what they've seen in the industry that one may not have a sense of. So when it's a foreign state, and I guess the third point I'd make is when a foreign state is involved, the resources that they can bring to bear, meaning the people hours and the technological resources, can be far more significant than a data breach from a kid in the basement in Estonia. And so those are 3 reasons why it may be more worthwhile talking to the federal government in that instance. And I'm not suggesting that's always the case. There are good reasons not to approach the FBI in certain circumstances, but it's a far more nuanced conversation internally to have. Yes, yeah.
Federal and state governments and bodies. You know, for example, the IRS, you know, all of our private institutions. So how do we monitor that?
So the question was basically who's watching the watchers? Who's keeping an eye on the cybersecurity of the federal government, for example? Well, as one of the people implicated in the OPM breach, you know, the Chinese probably have, I'm sure they already had all of my information given that I was at the NSA, but they certainly have my background information now. You know, I ask that question every day. Are you kidding me? That if it's true, the Chinese government stole some 20 million background clearance forms for people like me, which, by the way, for those of you who've never done those forms, includes every place you've lived, includes information about your spouse and kids, includes financial information, and includes, of course, social security numbers, and includes a lot of that personal information for your friends and family who you've listed as references for the FBI to call for your background. So it's a pretty significant thing for those forms to be stolen. So in answer to your question, on paper, the Department of Homeland Security is responsible for protecting the .gov domain. So earlier I talked about the information assurance mission of the NSA. So NSA is responsible for protecting domains that end in .mil, which stands for military, so the emails I was talking about the Army may need to send to a person in the field, or .ic, which is the domain for intelligence community. But DHS is responsible for .gov, so opm.gov, or pick your federal agency. Now, part of the problem has been DHS hasn't had sufficient authority to be able to impose its will on other federal departments and agencies, sufficient statutory authority. So we can point out flaws that OPM may have had, for example, but it actually had no legal right to require changes to be made. And some of those have started to be remedied, but they have yet to be, I'd say, come to fulfillment. So if you're asking, is there sufficient watching of the federal agencies? No, I don't think so, which is really discouraging, particularly since those are the regulatory agencies coming down on all of you, for sure. Anything else? Okay, well, thank you for your time, and thank you for coming to the firm today, and I look forward to the rest of the day.
Thank you,